Well, welcome everyone. Very nice to see you all. Matthew and I are very pleased you're able to join us for our brief talk on redundancy. Now, our aim is simply to remind you of some of the key principles rather than to provide a warts and all review. In terms of some ground rules for this webinar, there are happily very few. We're not actually able to see you, so any rude gestures will go unseen, and you're not going to be able to pitch in with any tricky questions on screen. So thanks for not being able to do that. If you do have any questions, please put them in the Q&A box function at the bottom of the Zoom panel, and we will, if we have time, endeavour to address them at the end. Now, we'll be sending slides and notes after the event to those who have attended today. And the recording of the webinar is also going on to YouTube, where inevitably it'll fail to compete with Singing Cats and the Top Gun 2 trailer. But should you be struggling to sleep, you know where to find us. And as you can see from the first slide, we're going to try and touch on those 6 points today, and we're going to chip in variously during the course of the morning. We appreciate that with 300 or so attendees due to join us, there's likely to be a range of knowledge and experience, and we will try to accommodate that in our talk. We also appreciate that you're likely to be busy, possibly even dealing with some of the issues raised by the talk. So if you need to disappear at some stage during the talk, we'll try not to take it too personally. In terms of timings, we need to bring the webinar to a close by midday. It's not just a way of avoiding any particularly gnarly questions you might have. I'm chairing a rugby disciplinary hearing for the RFU pretty quickly after this, and so need to disappear at noon. Now, before Matthew takes you through some of the key considerations for a fair redundancy process, a few brief comments from me by way of context. Now, redundancy is plainly an important factor for any employer when considering reorganising its business structures. Its relevance in the current economic climate is pretty obvious. Now, the focus from us today is on redundancy dismissals and the processes which lead up to them. Now, such has been the effect of the COVID-19 pandemic that employers are inevitably going to have to make changes to their workforces if they haven't done so already. Whilst job retention schemes have largely delayed significant layoffs, as those schemes come to an end, there's likely to be a hugely turbulent period ahead. Now, we appreciate that for some of you, the past 12 months or so will have been very difficult indeed for any number of reasons, with many of you having to field a range of queries about redundancy on a regular basis. Generally speaking, just as by way of comment, on an operational level, one of the crucial factors in any redundancy process, it seems to me, is making sure that an employer has a strategy to support any given workforce, probably through the human resources function. I suspect that many of those working in human resources will have had a particularly intense 12 months, and I suspect that that will continue for some time to come. Now, Matthew and I come at this from our experience in tribunal. Inevitably, we are involved in those few cases which are litigated and make it before a judge. So our emphasis might be, and hopefully is, of benefit and slightly different to those of your own. But often when giving talks, it can be beneficial trying to gauge which way the wind might be blowing in tribunal by seeing whether there are any shifts or trends, whether they're developing. What's really interesting here, it seems to me, that if the pandemic has an effect on the way in which tribunals view things, there's a fairly clear line in the sand, given the way things changed almost overnight in March last year. And most of the cases, aside from those relating to perhaps interim relief or such like, that have come about as a result of the pandemic, they haven't made their way to tribunal yet, at least not to a final hearing. And I think it remains to be seen how sympathetic tribunals will be to less than perfect practices that may have occurred from March last year. Now, my own view is that whatever may have happened at the hurry up last year is likely to be treated slightly differently to what happens this year, for example. Procedural shortcomings that occurred last spring might be forgiven, but employers who are now about to embark on redundancy process have, for the most part, been given some breathing space to consider their options through the job support schemes that are available. But going forwards, tribunals may be less forgiving, given the time employers have had to consider their options, to think carefully about the structural changes that they want to make, and importantly, the mechanism by which those changes are made. Matthew, over to you.
Thanks, Gareth. So I'm going to start with, as an introductory point, talking about how redundancy can arise and recognizing a redundancy situation. So we've got at section 139 of the Employment Rights Act, the statutory definition of redundancy, which is split into two parts, part A, part B. Part A is talking about the business as a whole, either ceasing or intending to cease carrying on a business. And part B, talking about reducing the work of a particular kind, or reducing need for work of a particular kind. And that, the definition, the statutory definition, covers really three broad scenarios. Scenario number one, closing the business as a whole. You're shutting the whole thing down, you're finishing. Scenario number two, closing a particular workplace. So to streamline the business, to make cuts, whatever it is, you're closing a particular site, the site where specific employees work. You've got a redundancy situation at that site. And then scenario number three, a reducing need for employees to do the available work. And the ways that those scenarios can come about are actually more broad, I think, than we might recognize. So the most common scenario that everybody sees, or that everybody thinks of for redundancy, is business struggling with cash flow, business losing money, less work coming in, we've got to make cuts, we've got to reduce headcount. That's a redundancy situation. But actually, the statutory definition is a lot broader than that, and the ways that redundancy can come about are much more varied. The other ways that it can come about are probably going to be more relevant and more common because of the changes that have come about with the pandemic. So as well as the less money coming in, making headcount reductions, we've got things like asset investment or automation. A lot of businesses have had a long time with successive lockdowns not trading. And rather than going on holidays and enjoying their time off, I suspect a lot of them have been trying to work out how they're going to trade once the lockdown's eased. That will have involved, for some of them at least, investing in assets, investing in automation of systems to make them leaner, more efficient when things open up. And if they have improved their processes, improve their efficiencies, they might have a reduction in the number of employees they need. That's a redundancy situation. Likewise, you might have a significant move online where you may have had bricks and mortar shops, outlets, customer interaction. With the pandemic, everybody's got used to doing a lot of stuff remotely, a lot of stuff online. So you may have a reduction in the need for face-to-face staff. And further outsourcing, some companies may, because of the uncertainties that have come about, move to taking some of the business that they previously did, outsourced it to others. So they may have done manufacturing and sales. Going forward, they're only going to do sales, and they're going to cut the manufacturing side. You've got to watch out for TUPE implications if you're in that kind of situation. But again, if you're choosing to close down a part of your business or a type of business that you did do, you're looking at redundancy situation. Now, financial decline isn't a determining factor. And this is something where, in my experience, particularly where you've got claimants in person in tribunal, there's often a lot of focus at tribunal on the finances of the company that's made the redundancy. And claimants will point to the balance sheets, to the company accounts and say, well, look, there's still the same amount of money coming in. And so how can this be a redundancy situation? Really important to note early on, financial decline isn't necessary. And if you ever have a situation where this is arising, well, there's a handy quote in the case of Kingwell, Mr. Justice Burton, that says quite clearly, look, you can have a successful company loads of work, but the company decides, well, I can carry out this business more efficiently if I reorganize it, and then I'll need less staff. You've got the same amount of money coming in, you've got the same amount of sales being made, but you can reorganize and have fewer staff. You are in a redundancy situation. And I said at the beginning, the statutory definition of redundancy is at Section 139 Employment Rights Act. Section 1396 specifically says that the cessation of work or the diminution of work can be for whatever reason. So it doesn't need to be for a financial reason linked to a financial reason. We've got as well the in Section 139 the possibility for temporary closures, temporary cessations to be redundancy situations, something that could become relevant as the furlough scheme comes to an end and CJRS comes to an end. We've had, I think, a lot of organisations that have been closed for periods of time with successive lockdowns. They've not made redundancies because they've been supported through CJRS and furlough. Once that comes to an end, you might find companies who are closing for short periods because of rolling lockdowns or temporary site-specific lockdowns. Temporary cessations of business can be redundancy situations as well. It's provided for in the statutory definition. And in the handout that comes out, there'll be a little bit of case law on that to guide you through the difference between what's a temporary cessation of a business and what's just closing for a short period to start the business up, to refurbish it, to keep it looking good. How long does it need to be closed for it to be a cessation for the purposes of a redundancy situation according to the statutes? The other difficulty that I think a lot of businesses struggle with is what's the difference between a redundancy and a reorganization? If we're saying it doesn't need to be finance related for it to be a redundancy, if I'm making changes within the business, how do I recognize when I'm in a redundancy situation versus when I'm in a reorganization situation? And the answer is, well, they're not mutually exclusive. You can have a redundancy that isn't a reorganization. You can have a reorganization that's not a redundancy, and you can have both at the same time, a reorganization that is a redundancy. The thing that you need to go back to, the thing that your clients need to go back to always, is the statutory test for redundancy. Do you have a reduction in the need for work of a particular kind? Do you have a headcount reduction? And there's a slew of case law. I've given 3 examples of cases on the handout there. They'll be on the slide there. They'll be in your handout as well. But the common thread that runs through all of the case law is fact dependent. Look at your particular case. In your particular case, is there a reduction in the number of employees doing the work, or is there just a repatterning, a redistribution of the work amongst different employees? So if you've got the number of employees staying the same and you're just moving the work around, that's a reorg. If you're reducing number of employees, reducing the number of employees needed to do the work, you're in redundancy, even if it might be a reorganization as well.
Matthew, before you go on, didn't you say recently, we were talking about this yesterday, didn't you have a case recently where a judge was unfortunately somewhat confused by the differences between the two?
Yeah, absolutely. This is not a problem that only comes up for employers trying to work out whether they're in a redundancy or a reorganization situation. You will sometimes get tribunals digging down on this as well. And so I had a case a few weeks ago in tribunal where an organization had made redundant, according to them, made redundant one of their senior employees. And the tribunal judge pointed out, well, the work still needs to be done. The work's just been shifted to other employees. And so there is a continuing need for the work. How are you saying you're in a redundancy situation? And again, it's a case of coming back to that statutory test, headcount reduction. Well, you've got a reduction in the number of employees needing to do the work. So you've got a reduction in the need for employees to do work of that kind, even though the work is still there, even though the finances are fine. And again, it was one of those cases where payment was particularly keen on focusing on company finances, the fact that the work is still being done, and all of those sorts of matters. So it shows that as a practical point, it comes up in tribunal. And the important thing, I think, for employers and when you're advising employers, is to go back to that statutory test and have a look at whether you're meeting it or not. And I think if there's ever any doubt, if you're doing a reorganisation situation that you think is a redundancy, if there's any doubt in it at all, if you get litigation on it, if you get somebody putting in a claim, make sure that when you're responding to the claim, you say, well, dismissal was for redundancy. In the alternative, it was some other substantial reason. It was a reorganisation. Because as long as you say that you are that you've got both grounds to be able to argue in tribunal, you won't find yourself caught in a position of it not quite meeting the statutory test for redundancy. You've got the fallback of saying, well, it was a reorganisation, some of the substantial reason for dismissal, and you can still demonstrate your fair dismissal. So I think really important to put those through. And final point in terms of redundancy situation and recognising redundancy, final point before we move on, mobility clauses in contracts. And this will link in, I think, as well to the increase in remote working with the pandemic. You can do you can have employees who have got a mobility clause in their contract when you're looking at whether a particular workplace has closed. If the employees in that workplace have got a mobility clause, are they in a workplace that's closing, or because of their mobility clause, are they not in a workplace that's closing? So, practical example, you've got somebody who works in South London, they've got a mobility clause that's in their contract that says they can be required to work anywhere in London. The work in South London dries up because a particular client vanishes, but the work in the rest of the London is absolutely booming. But that particular employee, given that they can be required to work anywhere, do they fall within the definition of redundancy? And again, the answer on this, thankfully, fairly simple. Look at the facts. Where do they work as a matter of fact? Don't worry too much about what their contract says. If they factually work at a single site, that is where they work when you're considering whether their workplace is closing. And there's a case on that that'll be in your handout when it comes out, Court of Appeal case, My Table Limited, which says, look at the fact, look at where they actually work. I just want to touch on a short note with collective consultation, because of very recent developments on collective consultation and how that might affect things that your clients might be doing, things that your clients might be looking at. And you will all know, I expect, that you've got obligations to undergo collective consultation under Section 188(1) of the 1992 Act, where you're looking at making 20 or more employees at an establishment redundant within 90 days or less. Fairly simple to apply that and to look at what the situation is when you're deciding to make your redundancies. The bump in the road has come from a recent ECJ case, UQ and Marketing Technologies. And that was about when you're looking at how many employees, when you're looking at getting to the threshold, can you add on people who are made redundant in subsequent redundancy processes? So the employee in that case was made redundant and said, well, hang on, after I was made redundant, some other people were dismissed in a similar way later on. If you add them together with me, you hit the threshold number for collective consultation. And that's what I want to do. And the employer was saying, well, completely separate redundancy processes. The ECJ said, well, when you're looking at a contested dismissal and you're looking at this reference period, in our case of 90 days, you look at forwards and backwards from the date that it's taking place. So it's not simply a case of saying, well, look, in this single redundancy consultation, we're looking at making 19 employees redundant. You've got to look forwards and backwards to see how many have been affected before and after this particular consultation. Practical effects, the things that you need to be looking out for with your clients. Look, if you're anywhere near the 20 employees, if you're anywhere near the number for collective consultation, have a chat with your clients about what other redundancy processes have you gone through recently, how many others have you made redundant recently, and how many might you make redundant in the very near future. Because if you could be ticking over 20, taking a rolling 90-day period, you might want to look at your collective consultation obligations, and you might want to have a really good read of that UQ case to make sure that you're meeting your obligations there. Let's talk then about individual redundancy situations, and this is the bit that really a lot of clients will need advice on. How do I, if I'm going through a redundancy process, how do I make sure that that process is fair? How do I make sure that process is going to be defensible in tribunal? And I'd say that there's 4 key pillars to a fair redundancy. So you've got the 4 on the slide: the pool that you're going to be picking people from, some selection criteria that you're going to be applying to that pool, and then the consultation process, whether that process is adequate and meaningful, and finally alternative employment. And so we're going to touch upon those each in turn now. Pool for selection. Now, I don't know about you, Gareth, this is, in terms of picking a pool, it's something that does come up with a degree of regularity in tribunal, in terms of people saying, well, other people should have been pooled with me, or I shouldn't have been put into this pool, I should have been put into that pool. It is something that people tend to argue about a fair bit at tribunal. In my view, but in my view, tribunal is pretty reluctant to get involved in the drawing of the pool. Tribunal is pretty reluctant to redraw the pool and to say it's been drawn wrong, unless it's either irrational or the employer hasn't genuinely turned their mind to it.
I totally agree, but I mean, in terms of following that through, it's often fairly easy, I think, isn't it, for employers to knock that argument on the head, provided they can evidence not just what decision they came to, but how they came to it and why they came to it. I think actually that's something that employers sometimes miss. They can simply call the decision maker and rather than just having this raft of meeting notes from earlier on in a consultation process where trade union might be involved or something like that, to say, here, this is the discussion that was had, actually to have evidence from the decision maker about the process they followed and why they applied their mind in the way that they did. I think that's something actually is fairly easy to argue.
Yeah, I would agree, and I think that's the area where employers can get themselves into trouble, just not evidencing at tribunal how they decided to draw the pool, and particularly in cases of a pool of one, that they'll turn up to the employment tribunal and say, well, pool of one, we picked a pool of one, there's our employee, and not actually showing the tribunal, which is a fairly easy thing to do, I think. Showing to the tribunal, well, look, here's a single sheet of paper where we sat down and thought about how we're going to draw this pool up for people that we might make redundant. This is what we thought about, and this is how we landed upon the pool that we picked. As long as you meet that kind of basic level, tribunals are going to be fairly reluctant to interfere with it. But as you say, I think employers will often fall down by just not having that piece of paper in existence or not bringing it to tribunal.
Agreed.
So the factors to consider when your client's drawing the pool, you've got the 4 on the slide there. Those are the sorts of things that will often be in their minds when they're deciding how to draw the pool up. The pitfalls that they might fall into. The most difficult situations come about, I think, with employees with interchangeable jobs or employees who cover for each other. So there's a case there, Blundell, Permaglaze and O'Hagan. That's about drivers and warehousemen covering each other's roles. And so, often you would have one type covering for the other, the drivers covering for the warehousemen or the warehousemen covering for the drivers. In a situation where you're making redundancies from only one of those types, so only the warehousemen or only the drivers, you've got the potential you might need to pool them all together if they can cover each other's roles, and they do regularly cover each other's roles. The other potential pitfall is pool of one. If you're selecting a pool of one person, you've got a pretty high litigation risk, in the sense of a pretty high risk that litigation is going to follow, because if you're ever going to find an aggrieved employee, it's going to be somebody who's been singled out for redundancy as a individual rather than being put in a pool with others. And the third potential pitfall is multi-site redundancies and whether to merge them into a single pool. Again, something that's becoming a lot more relevant with the increase in remote working. The historical arguments about keeping separate sites separate when you're pooling, those arguments might be less forceful these days because of the massive increase in remote working and because of the ability of people to work across sites. So just something for clients to bear in mind, that if historically they've kept sites separate when they're pooling, they might want to consider whether it's justifiable and whether it's right to keep separating them going forward. Selection criteria now, a couple of points on selection criteria for me, and then Gareth's going to speak about some particular difficulties that can come with it. There's a lot of, I think, hand-wringing that employers can go through about what criteria they should use to score people who are in the pool. General guidance, the objective versus subjective points. Try and use objective criteria where you can. So criteria that's verifiable by reference to data. You're talking about attendance or efficiency or appraisal scores. And try and avoid criteria which needs the personal view of the selector. So try and avoid stuff like which employee will keep the company viable or who is the most committed, because that sounds a lot like who do I like the most. And so you're opening the door up to real problems there. Don't feel that criteria have to be completely objective in order for there to be a fair dismissal. There is a risk, and it's come about, I think, certainly in the last 10, 15 years, that employers get a bit scared, probably because we advise them to be a bit scared about subjective criteria. And they feel that everything has to be completely objective, completely by reference to verifiable data, and there's no element of subjectivity allowed at all. I think that's going a bit too far, and you can get problems with it because sometimes the objective data that you've got won't measure exactly what you need for the company going forward. And there'll be, when the handout comes out, there'll be an example in the handout of a case where purely objective criteria is used, and it gave rise to just bizarre results, with the best employees being sacked for redundancy and the less good employees being kept on because they scored the best, even though everybody in the process was saying, this doesn't seem right. You know, employee X is coming out top, employee Y is coming out bottom, but we know that their performance is the other way around. We know that one of them is going to be better than the other. And so, you know, it doesn't have to be completely avoided, objective criteria. And in terms of when the tribunal is going to interfere, we're talking range of reasonable responses stuff. We're talking as long as you've done a reasonable job at selecting the criteria. And in terms of scoring, as long as the scoring process isn't inherently unfair, the tribunal aren't going to get involved in it. Do
you want me to pick up on that? Yes, please. Yeah, I'll go. I mean, pick up on that point about subjective versus objective. I entirely agree with the point you're making. I think employers can be too fixed on the idea of using objective data, and that can lead to problems, particularly actually when you still need potentially to have a degree of subjectivity as to when, you know, for example, the period over which to apply the objective data. You still need to think about that carefully. Let me pick up on the Equality Act stuff. Practitioners, you'll be acutely aware of the caution that needs to be exercised to avoid discriminating against anyone on account of a protected characteristic. It's obvious. The tribunals frequently deal with claims in which it's argued that a selection of an employee for redundancy is both unfair and discriminatory. And what Matthew's been talking about thus far largely focuses on fairness. One of the key reasons is obvious. It's because of the additional remedies which are available for Equality Act claims over and above those which apply to unfair dismissal claims. But just stepping back for a moment before I then come back towards the selection criteria, When determining the fairness of a redundancy dismissal, as Matthew's just suggested, tribunals are not normally entitled to investigate the reasons behind the redundancy situation. There's no requirement for employers to show they were forced into making redundancies, sufficient for the employer to simply to show they had a good commercial reason for making a change. That doesn't necessarily mean that a tribunal will take what they're being told by an employer at face value. Where an employee can establish facts from which discrimination could be inferred, the tribunal will look to the employer to provide a non-discriminatory reason as to why it acted in the way that it did. And it's fairly obvious, isn't it? If consultation's at a minimal level, the selection process is lacking in transparency, or there's been little effort made to find alternative employment, that's when employers are going to find it difficult to defend claims that the redundancy as a whole was a sham. Now, I'm going to come back to that a little bit later when I talk very briefly. You'll be very pleased to know about burden of proof, but it's obvious. The equality of all, quality of treatment is essential. But choosing the right selection criteria and making sure that the ways in which those selection criteria are applied is a fundamental aspect of that equality of treatment. Now, one would hope that most people will readily accept that you don't sack someone because of a protected characteristic. But most people are familiar with the idea of reasonable adjustments and how that might play out in a redundancy process involving those with disabilities for the purposes of the Equality Act. But understanding how, for example, a particular selection criterion will be considered by reference to indirect discrimination, I think is a little different. And in my experience, the problems come for employers. They don't really pause and think about the effect a particular selection criterion might have on a particular individual. It might be because of some inherent complacency when choosing the criteria. It might be that an employer, particularly if they're a particularly large organization, might trot out the same process that has worked before and not come up against any problems. But giving that additional thought, I think, is crucial. Now, rather than exhaustively go through all of the potential different selection criteria, which frankly could take all day, I will take a commonly used example and hopefully demonstrate the level of thought required. Can I have my Professor Whitty moment? Next slide, please, Matthew. Thank you. So the example I'm going to use is attendance. Now, it's a fairly standard measure used in redundancy exercises. It's largely objective. But it's also fairly obvious to think of the potential problems. So if absences related to disabilities are included, depending on the precise circumstances, this could lead to any one of a number of claims, including discrimination arising from disability, indirect discrimination, or a failure to make reasonable adjustments. Additionally, we then got things such as maternity leave. Plainly, maternity absences for maternity leave should be discounted. What to do? So if you're faced with a selection pool that you know might include, or employers know might include, someone who's potentially disabled for the purposes of the Equality Act, or someone's on maternity leave, what do you do? Do you just choose to avoid using such a criterion? Or do you think of a way of adapting it so that it fits the circumstances? And ultimately, it is a readily identifiable piece of data that can be measured objectively. But the key is obviously to consider the circumstances in detail. I appreciate that's somewhat easy to say and sometimes difficult to do, not least if the employer is under pressure to make changes quickly, or if the redundancy is particularly wide-ranging. But an employer has to do more, if we're talking about attendance, than just count days. It's far more nuanced than simply numbers on a spreadsheet. In relation to potential disability cases, it's all too easy to make assumptions about the impact a particular medical condition has had without taking the time, I appreciate it takes time, to explore it properly. Redundancy processes often happen quickly because an employer may be required out of necessity to make changes quickly. But it's still incumbent on employers to find out what the up-to-date medical position is and to ascertain what the real effects are of any potential disabilities. As I've said, this takes time, particularly at the moment where health and safety professionals have other things on their mind. An employer should seek to allow for such time in any redundancy process before it commences. Let me return just briefly to this point about maternity leave, because it's interesting. It's a fairly obvious point again. It's likely if you use it and you include someone who's on maternity leave and they're absent, then plainly it's going to be an act of discrimination. But without due consideration, actually it might, if you don't use it carefully, if you don't think about it carefully, an employer might overcompensate when carrying out a selection process involving a woman on maternity leave. Now there's a case here that I think helps. I'll mention it in the handout too. Let me just give you a brief outline because it has wider implications now, I think, than just the sheer facts of the case. It's a case called Eversheds and Berlin, where the EAT upheld a tribunal's decision that a law firm had discriminated against a male lawyer on the grounds of his sex. Now, one of the criteria used, relating to financial performance was that of unbilled work in progress. Mr. de Berlin had scored the lowest on this criterion. He had a score of 0.5. Ms. Reinholz, who was on maternity leave at the time and had no unbilled work in progress, was awarded a notional score of 2. Now, in the grand scheme of things, that became critical because Mr. de Berlin scored 27 points and Ms. Reinholz scored 27.5. Now here, the tribunal found that the employer had overcompensated for Ms. Reinholz's absence. What they held was that the obligation was to do that which is reasonably necessary to afford the statutory protection to the woman who is pregnant or on maternity leave. The tribunal concluded that the employer should have chosen a historical period relating to this element of financial performance when Ms. Reinholz was actually at work so that a proper score could be attributed to her. Now, I've mentioned this case in particular because it seems to me that it might have real application now, given the numbers of people that will have been away for a variety of reasons, including because of protected characteristics during the period of furlough. And I'll return to that very briefly later on. Matthew, back to you.
Thanks, Gareth. Just while we've been talking about selection criteria and bits like that, we've had a question come in from Jane Harrison. You should be able to see the questions by the things. She said, should an employee be given an unredacted, with names, copy of the selection matrix during the ET proceedings? So where you've done your scoring somebody, you've got an ET claim, they're challenging the scoring, should you give them a copy of the selection scoring that was done with the other employees so they can check themselves against them and see whether the scoring was fair? There's, to help you out, Jane, there's a couple of points on this. The starting point, and a couple of cases actually, the starting point is the case of Eaton and King, in which the tribunal say, well, you haven't got to prove that you've scored everybody absolutely correctly. What you've got to do is show that you've set up a fair system and that the scores appear to be, that the system appears to be executed fairly. So for an employee to challenge the individual scores, they've got a pretty high bar. They've got to show some sort of case that there's been unfair or inappropriate scoring. They don't just get to get the tribunal to rescore it automatically. And in terms of disclosing copies of the selection matrix and disclosing copies of the scoring, another case, British Aerospace and Green, where the employee was seeking a copy of the scoring that was done. The tribunal didn't order disclosure in that case. It was quite a large-scale redundancy because it was a fishing expedition to get the scores of everybody else and simply try to see whether you can spot people who are overscored or underscored. Isn't something that the tribunal will order disclosure of. They're not going to let you just see everybody else's scores to see if you can pick it apart on an over-minute analysis. The tribunal is just looking to see, is there a system that has been set up fairly? and does it look like it's been fairly applied in the kind of broad sense? They really don't want to get involved in individual scoring. So generally speaking, no obligation to give the scoring matrix. As a practical point, if you've got a fairly small scale redundancy exercise, then it may be quicker and simpler to just give a copy of the scoring matrix if you're confident in it, and it can knock the claimant's arguments on the head. If you've got a larger scale redundancy exercise, you're going to be much more reluctant to go through disclosure of it because it's going to extend the costs that are going to be incurred in the proceedings and the level of detail that you're going to be going into, the level of documents and disclosure and so on. So from a practical point, I'd say it depends on the size of your redundancy process. I'm just going to move on now to the next topic in our slides, which is individual consultation. So this is the third pillar of a fair redundancy, consultation with the individual. So separate from collective consultation, whether or not you needed that, for individual consultation, three key principles. These come from the cases on the slide, Mugford. If you don't consult, your dismissal is normally going to be unfair unless it would have been absolutely futile to have consulted. So make sure that you do some level of consultation. If you consult with a trade union about the criteria, that doesn't release you from the obligation of consulting with the individual employee who's being selected from redundancy. So individual consultation is still necessary. And the ET is going to be looking at the overall picture of the consultation process. They're not going to pick out one particular mistake and say, well, there you go, dismissal is automatically unfair. They're going to stand back and look at the process as a whole. What does fair consultation look like? Again, some really helpful guidance from another case, ex parte price, where the High Court sets out what it's going to look like. You need consultation when it's still at a formative stage, adequate information to respond on, adequate time to respond, and one that I think can easily get overlooked, conscientious consideration of the responses to the consultation. So in short, what we're talking about is an opportunity for the employees to be involved at an early enough stage and to be listened to so that they can shape the redundancy process. And there's actually potential positives for the employer in having effective consultation. You've got the possibility that employees will come up with ideas to help you make the cuts you want to make or make the savings you want to make in a way that turns out to be more beneficial to the business. Although the business may have come up with its own ideas, it ought to approach consultation not completely wedded to those and still with an open mind. And the benefits that you can get are sometimes in a consultation process, employees will suggest, well, we'll take pay cuts rather than making redundancies, or some of us will move to part-time working rather than having a headcount reduction. It may suit the business to have that. And also, it's likely to suit the business to have employees who have a buy-in to the process, employees who are, generally speaking, happier about the process because they're much less likely to make claims. So the consultation process can be, I would say, a real opportunity to get both happiness amongst the employees and also to get more brains thinking on the problem than simply the board of the company. And in my experience, it can often be used as an opportunity to tell the employees what's going to happen rather than have more of a kind of two-way dialogue about it or an opportunity for them to be involved in it. So those are the potential benefits for the business. You've got the employee ideas, the alternative cost saving, and the reduced risk of litigation coming out of it. The fourth pillar of a fair redundancy is alternative employment. I'm going to talk on it for a moment, and then Gareth's going to speak about some specifics for particular types of employees. The things that you need to be looking at are tailoring it to the individual, I think, is the biggest issue. although there may be fewer opportunities around, post-COVID, post-lockdown, etc., and generally most businesses making redundancies don't have a lot of jobs going spare, when you're looking at alternative employment, the one pitfall, I think, or the most common pitfall, is making assumptions about the person who's being made redundant. They're in a role with a particular level of status, or they're in a role with a particular level of speciality, and there's an assumption that they only want something similar. That's the danger, I would say, for employers. You've got to look at the individual and speak to them about what else they might be willing to do, or what other opportunities they might want to look at, rather than being made redundant. Because in my experience, the ones who, the most common arguments that are raised at tribunal on this issue are people who say, well, look, they never gave me a list of the vacancies that were available within the company. And yeah, I've been working as, assistant MD or CEO for the last 5 years, but I would have been quite happy going and cleaning the toilets as long as I kept my job. It's an extreme example, but that's the sort of thing that people are saying. I would have taken a slightly more junior role within the same area, or actually I was looking for an opportunity to move to the commercial department, so I'd have been really interested in vacancies there, but just nobody told me that these vacancies were available. So the practical steps to look at avoiding litigation, avoiding claims in this area, are speak to the individual, make sure that they have an opportunity to look at all the vacancies within the business. And there could be an opportunity, if you've got a group of companies, there could be an opportunity or a requirement rather, to look at vacancies within the wider group. And it came up in a case I had just over a year ago, where somebody was employed by a subsidiary of a university in a HR function. Redundancies being made within the subsidiary, vacancies were available within the wider group within the university. No efforts made to look at vacancies within the university. And there had been a history of people moving between the two employers from time to time. So it was possible to move from the university to the subsidiary and vice versa. And in that case, tribunal found unfairness on the basis that there hadn't been any effort to look at vacancies within the wider group and the opportunity to move within the wider group. So Gareth, some particulars to look out for.
Happily. Back to particularly those women on maternity leave, it's important to remember some aspects related to this. So in relation to, we've got the standard, if I can call them that, fairness requirements when considering suitable alternative employment, but it is important to remember that some categories of employee have preferential treatment for redeployment. For example, women on maternity leave are entitled to be offered a suitable vacancy, and if they're not, they'll be treated as automatically unfairly dismissed. Now, the rights enshrined in Reg 10 of the Maple Regs or the maternity and parental leave regs, worth just reminding you as to what they are. It's a three-step process. The starting point is if it's not practicable for the employer to continue to employ the woman on maternity leave under existing contract of employment, but where there is a suitable alternative vacancy, the employee is entitled to be offered that role. And as Matthew's just said, we're talking now potentially about wider aspects of the organisation. So it's not just the employer, it's potentially the employer's successor, but also an associated employer. And as to that new role, the stipulation is as follows: the work must be suitable and appropriate in the circumstances, and the terms must not be substantially less favourable to her. Similar provisions apply to persons on adoption leave and shared parental leave. But crucially, there is a difference when looking at alternative employment compared with the initial selection for redundancy that we covered earlier. As we've looked at in relation to billing, a woman on maternity leave is not entitled to preferential treatment in the actual selection for redundancy. The requirement there is to do that which is reasonably necessary, and the response must not be disproportionate. But when considering alternative employment, once a post has been made redundant, a woman on maternity leave is entitled to preferential treatment. By way of brief example, Sefton Borough Council in Wainwright, the council were under significant financial pressure and decided to restructure in response to budget cuts. The council decided to delete 2 posts, that of Ms. Wainwright's and that of her colleague at an equal grade. They created one single new post, which was ring-fenced for them. The selection was, the employer thought, a fair way to decide the selection was by way of competitive interview. But at the time, Ms. Wainwright was on maternity leave. On the correct application of Reg 10, the AT held that Ms. Wainwright had the prior right to be offered the new job without having to interview it. Reg 10 was triggered as soon as the council made the decision to delete 2 existing posts and make both roles redundant. Now, I think it's helpful, frankly, if I read out the next bit, which is the rationale. And it's worth having this in your mind if you're ever to deal with a redundancy situation involving a woman on maternity leave. As Honourable Judge EDQC said, here the protection is afforded to women on maternity leave because of the particular disadvantage that they suffer in engaging in a redundancy selection process and competing for whatever job remains. In order to afford the claimant the protection she was entitled to under Reg 10, once a position was redundant, the respondent was obliged to assess what available vacancies might have been suitable and to offer one or more of those to the claimant. She should not have been required to engage in some form of selection process. It's also important to remember, going back to the point Matthew started off with, reorg versus redundancy, that Reg 10 applies on a restructuring when a new role arises. So all good so far. Important to remember the multiple strands here when looking at the degree of protection afforded to various categories of people. But it's also important to remember, and this is a wider ranging point, I think, that the burden of proof provisions in the Equality Act continue to apply. Well, yay, I hear you shout. We don't need to cover the nuances of the reversing burden of proof today, but I'll mention a case to demonstrate that dismissing a person with a protected characteristic does not necessarily reverse the burden of proof to the employer. I know that employers get understandably very nervous when potentially making someone redundant who has a protected characteristic. This is the case, it's on the slide, a Bar-Roma partnership, where it was held that it was not possible to infer prima facie discrimination just because the only employee who was dismissed, supposedly by reason of redundancy, was selected for redundancy a few days after she announced to her employer that she was pregnant. Now, I appreciate that this is a case that revolves actually around selection criteria, so it doesn't necessarily fit neatly within this alternative employment point, but I think it fits within the overarching scheme that said employers get nervous about dismissing those with protected characteristics. And it's the point about burden of proof is of universal application. As Mr. Justice Langstaff said, the claimant couldn't hope to show that she was dismissed for redundancy because of her pregnancy unless she could show the following. A, there was no genuine redundancy, and B, the criteria for redundancy lacked proper objectivity, or alternatively C, the scoring of the matrix was itself not objective but was influenced by pregnancy. So the burden, as it should be, was on the claimant to demonstrate that there was some evidence upon which the tribunal could conclude that an act of discrimination had occurred. It was not enough, and I'm sure we've all seen it, it was not enough for her simply to establish that she was dismissed and was pregnant to the knowledge of the employer. There we go. Over to you, Matthew.
Thanks. Yeah, and I think that's a good point. You often get claimants bringing claims saying I was treated badly because of my protected characteristic, and the only thing they can point to is the fact that they've got a protected characteristic, as you say in your example. I think tactically, those sorts of cases are pretty difficult to strike out in the employment tribunal, because if you get it struck out, then the EAT may well put it back in because you can't really strike out discrimination claims. But worth a go on a deposit order. And the case that you've mentioned is really useful. And there's another one, EMEA and BA, that essentially says you've got to show something other than I've just got the protected characteristic. You've got to be able to point to something actually to back it up. There's just one thing I want to touch on. We've done the 4 pillars of a fair redundancy, and there's one thing that I want to touch on before we get to a finish, and Gareth's got one more topic to run through as well, which is calculating the statutory redundancy figure. This only applies to statutory redundancy figure, not to any contractual redundancy figure. And the statutory calculation, section 162 Employment Rights Act 1996. The reason I want to touch on it is, look, furlough calculations were a nightmare for employees who don't have for employees who get paid a different amount depending on how much they work or how much work they produce. For statutory redundancy calculations, you've got the same problems. If you've got an employee who is on a set wage, no matter what, no matter how much work they do or how much work they produce, nice and easy. If you've got someone whose pay varies with the amount of time, amount of work they do or the amount of time that they're working, then you've got to do the 12-week average. Problem with the 12-week average in the current climate: absence from work and change in hours or pay. So where you've got absence from work in the 12-week average, if they're not at work and they're not entitled to be paid, you continue counting back until you've got 12 weeks where they are at work and are entitled to be paid. So employees volunteering or helping out at work without the entitlement to be paid, don't count those weeks. Where you've got employees who are on furlough, you need to top them back up to full pay when you're calculating your statutory redundancy calculation. If you've got someone who's got an unusually low earnings for a single week for a non-furlough reason, they just did short hours for a week, they're going to get less for their statutory redundancy pay. It's bad luck. If you've got a change in pay, and this is going to be particularly relevant at the moment, if all the employees have agreed to take a 10%, 20% pay cut, or to cut their hours from 5 days a week to 3 days a week to try and help the company through difficult times, if that is a permanent agreement, then their redundancy calculation is calculated on the basis of their new lower pay. If it's a temporary agreement, we'll just take a 10% cut until times get better, then it's to be calculated on the basis of full pay. And there's a really good example of a case there of a temporary change to help the business through bad times. But this is the sort of thing that I think is going to be quite relevant at the moment in terms of adjustments businesses are made because of the COVID situation, because of the downturn in business. Talking about furlough, Gareth, you've got a little bit to tell us about that.
I have the dreaded F word. It's almost as though we've planned, Matthew, on filling the time substantially so that we don't have to worry about fingers and thumbs and talking too much about the calculation of redundancy pay. And also, I suspect I've seen that there are some questions that have come in that I suspect we're going to be running out of time to deal with. I'll come back to those. I've seen there are actually a couple of questions that have come in which are kind of related to the topics that I'll just mention briefly now. So I'll try and pick up on those. You'll be pleased to know I'm not going to talk about furlough in any detail at all. There are really just, I think, a few useful things to mention when it comes to redundancy situations and the way the tribunals may look at things going forwards. The first is I think that there are enormous bear traps, frankly, awaiting employers who repeat any errors that may have been made at the start of the pandemic when furloughing employees quickly. I accept entirely that we all had to change our working practices enormously at the beginning of last year, or this time last year, and mistakes will have been made inevitably given what was going on at the hurry up. But if you simply repeat those mistakes going forwards, I think you will come you'll fall into error. And the other, which as Matthew has already touched on, which is the possibility that working from home, furlough, might well have changed things in terms of perhaps an employee's pool size or perhaps alternative employment that they might be willing to engage in. Now, again, overarching first principles, the law of redundancy and the stuff we've been talking about hasn't changed at all. And I think it's important to remember that employees might be under the mistaken belief that employers can't make redundancy when furlough is being used as an option. That's plainly not the case. It's frankly and sadly inevitable that employers who've used the various support schemes that are available may also have to reduce headcounts if they haven't done so already. And I accept entirely that many of you watching today, if you are in fact still watching, have spent a considerable time last year advising employers how to use the furlough scheme and how to ensure some form of fair process to choose whom to furlough. But from what, and it's purely anecdotal, from what crossed my desk from April last year, it seemed to me that employers moved quickly to furlough employees, often without any sophisticated selection processes. And dare I say it, it was very much that point that Matthew made earlier about an employer saying, well, how are we going to cope for the next few days, weeks, months? Who do I want around to be able to help me? Let's pick that person. Now, if employers don't look to reset those situations and those decisions, I think problems await. I suspect, as I've already said right from the get-go today, tribunals might be sympathetic towards less than perfect practices which occurred last year, but I think we're much less forgiving as to what happens subsequently. There, of course, is a natural correlation, isn't there, between the roles that were furloughed, I suspect, and the roles that are likely to come about for the purposes of redundancy situation. But I really do think it would be sensible to carry out an entirely fresh review of the business and to disregard the fact that an employee was on furlough in any redundancy process, simply to ignore that process. Now, I think this will help in a number of ways. Obviously, there aren't any hard and fast rules, and every situation is different. But if employers, have furloughed staff with caring responsibilities, it's highly likely that that will have a significant impact on female employees. Likewise, the requirement to shield during the pandemic is likely to have affected those who are disabled for the purposes of the Equality Act. The prospect of indirect discrimination claims again loom large, as if there are disabilities at play, claims of discrimination arising from disability. Now, thinking back to de Billing, forgive me for relying so much during the course of this talk on that, but I think it's important. The idea of measuring any objective performance data which is affected by that period or any period of furlough, be it whether it's that person who's been away or others as part of that group, I think it's likely to be problematic. Starting afresh and importantly with clear evidence trails of that to that effect will help undo any mistakes that did get made or things that were missed at the hurry up in spring last year if a business took a rough and ready approach to furlough. The second point, Matthew's touched on it, our working practices have changed. Many people might now be able to work from home or remotely where previously it wasn't thought possible. Now, on the face of it, how does that matter? Of course, at a simple level, it might be that employers can simply have a greater degree of flexibility going forwards, all well and good. But in relation to the 4 pillars of redundancy that Matthew referred to earlier, at least 2 of those are potentially going to have changed as a result of changing working practices. So foreseeably, the size of the pool might have increased if a group of employees has been working from home. You can think that perhaps geographical location might not be as important to a particular group now, 12 months down the line, than it might have been before, that line in the sand about which I talked earlier. And likewise, as for alternative employment, it's not just a question of someone who might be, I think, willing to clean the toilets, having been CEO before, but who knows what skills might have been gained during the pandemic. Now, I appreciate that that doesn't apply to me. I spent most of my time running around after 2 little hooligans trying to chase them around the fields. But some will have been particularly industrious and will have learned new skills and gained new experience. It may be that employees might be very keen to move now, where previously they might have been reluctant. So again, geographic location is not potentially so relevant, or they might be able to retrain more easily. Or where a role was thought of traditionally as not being able to be done remotely can now do so. So as I've said, selection criteria is something that should be considered very carefully, and I think employers should focus on data from pre-pandemic rather than post. And for some employers, I accept entirely that nothing will have changed, but it seems to me that clearly evidencing not just what has been decided, but how and why is hugely important. Now, I'm conscious of the time. It's 5 past 12. I need to disappear shortly. Let me just pick up on a couple of questions and touch, if I may, on the question of complaints during the course of the redundancy process. We've had a couple of questions on that, and I can just pick up that on very briefly. We know, and it's common, right? It's common for employees to raise complaints during any redundancy process. You will be familiar with advising employees, employers, of the respective merits of dealing with a complaint as a separate grievance or as part of that redundancy process if the complaint is in some way intrinsically linked with the redundancy process. Generally speaking, both might, depending on the circumstances, be reasonable depending on the nature and timing of the complaint. Obviously, complaints of discrimination or protected disclosure, whistleblowing, have got to be treated very sensitively. It might well be necessary to deal with the complaints remotely, depending on the prevailing situation at the time. An employee, it's worth remembering, an employee who is on furlough can still raise a grievance and can take part in that investigation and hearing process remotely. ACAS provided an update to their advice on disciplinary and grievance procedures that covers that. I'm sure each of you watching this webinar can think of situations where complaints may not have been dealt with as well as they could. Each of you, I'm sure, will have your own top tips that you remind those to whom you are giving advice as to things that they should be aware of. For me, I don't know whether, Matthew, you've got any points you want to add on this, but the following points routinely come about in tribunals, and frankly, they make for easy point scoring from a claimant's perspective. The first, these are obvious, but they still get missed. Deal with that complaint promptly. Reticence to deal with the complaint, or worse, investigations that then are fatally flawed as a result of any delay, should be and can be avoided. It helps, I think, to make sure that if an employer is going down the route of having a redundancy process, that they take account of complaints that might come about as part of that redundancy process and have the mechanism, I'm not going to use it, ready to go, not oven ready, ready to go up and when the redundancy process starts. It makes sense to build it into the timeline before they become a problem. Make sure you deal with each constituent part of the complaint. There's no point dealing only with the easy bits and leaving the difficult bits that are really likely to become source of litigation later. And ensure that the person investigating or dealing with the complaint is senior enough to deal with it. Often redundancy situations come about from the top, or they've been guided by people at the top end of the tree. There's no point having someone, if the complaint is about, goes to the very heart, is about the root of the redundancy situation, there's no point having someone who's not senior enough to deal with it if that's the case. So make sure that you do. As I've said, tread carefully when it comes to those complaints about protected disclosures or about protected characteristics. Make sure that the appropriate policies are followed. And of course, make sure that you have a robust appeal process and that it's catered for properly. And finally, I'm sure we've all had this, remind employers of the statutory definition of whistleblowing detriment and of victimisation. And I'm sure in your own gentle way, respectfully remind them the sorts of problems that come about if an employee is treated poorly, and I'll simply put it as that, if as a result of having raised a complaint. There we are. I hope that helps. Matthew, are there any questions that we've got that we can wrap up in the last couple of minutes, or shall I bring this to a close?
So what I've done, for those who are still on the call who have been able to stay with us, I've answered a couple of the questions in the Q&A box. I've put some typed answers in there.
Nice, thank you.
If there are any that we haven't been able to get to where we can, we'll get in touch and answer those, or make sure they're answered in the handouts. On the complaints issue you were just dealing with, Gareth, I'd agree. In terms of timings on complaints, a really common issue I get at tribunal is where the complaint has gone to somebody who's just too busy to deal with it quickly, and it ends up being delayed and delayed and delayed. So make sure that when you pick in somebody to deal with a complaint, they've got the work capacity to deal with it, to take it on. But I think that in terms of the talk, I think we'll draw it to a conclusion there. It's been really helpful having the questions that have come in from people to look at the topics that we've been touching on. And thank you everybody very much for joining us. Gareth, I think you know when our next webinar is going to be. It's summertime, isn't it?
Over the summer at some stage. I'm not sure that a date's been pinged in the diary yet. I'm sure that whenever it takes place, it'll be advertised widely, and the member of the team organising will look forward to seeing you then.
We will sign off there then. Thank you very much for joining us, everybody.